Welcome to the Retirement DNA podcast, brought to you by Dwayne Johnson and Aaron Johnson. We believe you deserve financial advice based on your best interest. In our podcast, we discuss all aspects of retirement planning. Today, we're going to cover another one of the 5 major areas that we covered during our financial planning for our clients. And today, we want to talk about estate planning. And to do that, we brought in George Chant. George has been working with the Dwayne Johnson Group and Bridger Financial Services for a while now, and we refer a lot of our clients to see him. So, George, thank you for being with us today.
My pleasure.
So I want to start off just by asking a couple of different questions for you. First of all, how did you become an estate planning attorney? Of all the different areas of law to practice, why this one?
Well, when I first started practicing, as you said, there's a lot of different areas in which one can practice. But I discovered early on that I did not enjoy the combativeness of litigation. And there are some areas of law that I had no interest in pursuing, like criminal law. I've got no interest in pursuing family law, which predominantly deals with dissolutions of marriages and tends to be kind of contentious. And so I gravitated towards something where I could employ my services more as a counselor than as a litigator. And estate planning is ideal for that. It gives me an opportunity to meet great people and work with them to resolve issues that they felt in many cases were unresolvable. They thought was too complex, or their family situation was far too unique. And I enjoy working with those people to help them find an estate plan that's going to be just right for them.
Oh, good. So how long have you been an estate attorney?
Since 1986.
Okay, so just a few years now. So a lot of times when we say estate planning, we find in our seminars or in our meetings with clients, people don't really know what that is or what it encompasses. So can you tell me, what is estate planning?
Well, there's more than one phase of estate planning. I like to divide it into 3 phases. One is estate creation. The next part, and estate creation is usually when you're first starting out and trying to compile your assets. And then there's estate preservation, where you want to make sure that you hang on to what you've got. And then there's the estate distribution in the event of your passing, going to the next generation or to whomever your beneficiaries may be.
Okay. So one of the kind of the common beliefs out there is that if you don't have a lot of money, you don't need to do estate planning. Is that true?
Well, estate planning is not a commodity. It's not like you can go to the store and say, "Ooh, I want that," and then you just pick it. Estate planning is really tailored to the specific needs of the individual. And not everybody's situation is the same. Not everybody's objectives are the same. And so somebody may need a very simple estate plan, which may comprise of things like wills and powers of attorney and things of that nature. And other people might have a much more complex estate, which requires a more complex estate plan, which may involve various kinds of trusts and or other business entities like limited liability companies and or corporations. Trusts come in many varieties too, whether they're revocable or irrevocable. And so it just depends on the individual circumstances. There's no person that I've met with who had so small an estate that they didn't need to do some planning, and nobody who had so large an estate that they were so overwhelmed that they couldn't do their planning.
Okay. And there's a lot of misconception, too, that we find that a lot of people just don't really know what the difference between a will and a trust is. So can you explain that a little bit?
Yeah, lawyers like to talk about wills in terms of being testamentary instruments. That is, it's a document that becomes effective in the event of your death. Wills really do nothing for you as long as you're alive. Trusts, on the other hand, are alternatives to testamentary instruments, but they are living documents for the most part, documents that become effective while you're alive. They can be for your benefit while you're alive or for somebody else while you're alive. And then in the event of your death, they become a will substitute. They can become testamentary instruments once you're gone. So wills have a very narrow and specific purpose, and trusts are much more you can customize a trust to meet almost any situation.
Okay. And And a trust is not contestable in court. Is that correct?
That is not correct.
Okay.
Any document, whether it's a contract, a trust, a will, anything can be contested in court. Will contests and trust contents are both handled in the same court in California. That's in the probate court. There are similar rules that govern both of those things. In California, the predominance of the law is to give great deference to the purpose of the testator, that is the person who wrote the will, or the grantor, that is the person who wrote the trust. So to the extent the court can determine what your intent is, they will work to help enforce that intent. If there's ambiguity, then you're asking a judge basically to flip a coin to resolve what that ambiguity means. But yes, trusts can be contested just as wills can be contested.
Okay. So what happens if someone dies without a will or a trust?
Okay. In California, if you die without a will, that's the technical term is dying intestate, that is without a will. And then the California law of intestacy comes into play to determine what happens to your assets. Let me begin by saying that any asset that you have that has a beneficiary designation, for example, life insurance, you can designate a spouse or a child or a friend as the beneficiary. Your will would have no control over that. The beneficiary designation controls. But to the extent there is not a co-owner that would inherit or a beneficiary that would take by that beneficiary designation, then the law of intestacy would take over, and it would depend on your marital status and children and all that to determine who would inherit from you at that point.
So it's very important to make sure that on your 401ks or any accounts that you have your beneficiaries correct and not just rely on the trust or the will. Is that right?
Correct. There should be great care taken to make sure that you've customized your beneficiary designations so that they're compatible with you designated in your trust or your will.
What would you say is one of the most common mistakes you see people making when trying to create their own estate plan or their own will or whatever it might be?
Well, one of the most common mistakes is people give common meaning to certain words that are very specialized in the estate planning arena. And if it comes down to interpretation of a word, the court is going to interpret that particular word as if you were an attorney that understood the legal meaning of that word. And I'll give you an example of that. Back in the late 80s, I had my first holographic will, that is a will that somebody wrote on their own hand, which was beautifully done, and it was a husband who left everything to his wife, or at least that was his intention, but he used the language, I leave all my personal property to my wife. Not understanding that personal property is very specific in what it entails. For example, personal does not include real estate. Personal and property includes things like your automobile and your furniture, furnishings, things like that, perhaps your bank accounts, but it does not include land. Well, and if he had only had the contents of his house, he left that all to his wife. Since his will was silent beyond that, he just said, I leave all my personal property to my wife, then the law of intestacy kicked in and said what to do with the rest of his estate, which was predominantly real property. So he had maybe a couple of $1,000s in personal property and hundreds of $1,000s in real estate. And intestacy said that wife would get 2/3 of it and his children would take 1/3 of it. And that's not what his intention was, clearly. But that was a mistake where he thought the language that he used would accomplish the goal that he wanted. So if you're going to do your own estate plan, my suggestion is at least pay an attorney a few dollars to review it for you to explain what the consequences of the language that you use would be.
Oh, that's good advice, because we've seen, and I have met with clients where they have just written out on a piece of paper their own will, haven't had it notarized, haven't had anyone even review it, and that's what they want to just have done, and we've just encouraged them to at least have someone take a look at it and make sure it's okay.
Exactly.
So we hear a lot about wills, trusts, medical directives, things like that. Is it important, is it necessary to have a will, trust, and medical directives?
Well, it's not necessary, but it's sure advisable in most circumstances to have, at a minimum, things like a will and medical directives, probably financial powers of attorney as well as the medical directives. And in many situations, it's also advisable to have a trust. It all depends on what your objectives are. If your assets are going to avoid probate anyway, for example, you've got insurance and bank accounts and you've named beneficiary on those assets and you don't have any real estate, then getting by with a will should be fine. As far as medical directives, the need for that usually arises when it's too late to create the document. And so it's advisable to have that before the need arises. Otherwise, you wind up in a situation where there may be disagreement between the medical community and your family as far as what treatment should be pursued if you're not able to participate in that because of your incapacity. So it's always a good idea to have a valid current medical directive that reflects your current wishes, and financial powers of attorney as well. And both of those documents can be what we call springing powers. That is, as long as you're alive and well, your agent under your financial power of attorney doesn't have the authority to sign your name to documents. But as soon as you become incapacitated and that's certified by your physician, then they have the authority to act under that power of attorney. So you don't have to worry that there's somebody out there who's got the authority to sign your name without proving that you're not able to do it for yourself.
Okay. And if someone has a will or trust that they had created when they lived in another state and they moved to California, is that will or trust good here as well, or do they need to have that updated?
It is good in any state in the Union under the 14th Amendment to the U.S. Constitution. All states have to give full faith and credit to the laws of sister states. Having said that, as long as the trust or will was properly created and was effective under the laws of the state where it was created, then it's valid in California. That is not to say that it shouldn't be reviewed in California, because there may be additional benefits under California law that may not have been available under that previous state's laws. And so it may be wise to have it amended to comply with that, to get you those extra benefits, or to see if there's other things that might not be compatible between the state laws.
Is there a time frame between when a trust or a will is created that it should be updated?
I advise my clients to review it periodically, and that period really depends on personal circumstances and the world at large. If there are changes in your family situation, changes in your financial situation and things like that, that may be a prudent time to have your estate planning documents reviewed to see if they still are accurate and reflecting your wishes and your current circumstances. Other things, if you read about or hear about changes in the law, whether it be federal tax law or California law as far as different things are concerned, it may be worth inquiring of an estate planning professional to see if your estate plan might be affected by that. When I say periodically, the period, it's not every year, it's not every couple of years, it's just on a periodic basis when the need arises, it's a good idea. But I wouldn't let too long go on. And I can't tell you the number of clients that have come in with a trust that were created decades previously and they haven't looked at it since then. And when I explain to them what it says, they said, oh no, that's not what we wanted. And so it's a good idea to review it sooner rather than later. But certainly it doesn't have to be done every year, but just as your circumstances dictate.
Okay. And what are some of the most common questions that you get from clients or people that are sitting down and doing reviews with you?
Probably the single most common question is, if I have a trust, why do I need a will? Because when we do an estate planning portfolio package for clients, we do a revocable living trust, and we also do wills to go with that. We do powers of attorney, healthcare directives, a whole combination of documents. The reason for that is because trusts govern the assets that are held by the trust, owned by the trust. Your will covers all assets that are not covered by the trust. So your will covers your probate estate, your trust covers your trust estate. And sometimes when you pass away, there are assets that you intentionally left out of the trusts. And there are assets that are unintentionally left out of the trust. The most common way that happens these days is people put their house into their trust years previously, then interest rates go down and they decide to refinance. And the bank says, well, it's got to come out of the trust in order for us to give you this loan. So they transfer it out of the trust, and then the house is never transferred back into the trust. So that house is inadvertently left out of the trust. Which can be problematic for a surviving spouse. It's not devastating, but it's certainly a circumstance that they shouldn't have to deal with. Another situation where an asset that you weren't planning on may be outside of your trust and your will would cover is if your death occurs as a result of somebody else's negligence and your estate has a lawsuit against somebody and there's an estate recovery. And so now your estate is paid to a probate estate, and your will would determine what happens to it. So the wills we prepare with our trusts are a specific type of a will that we use the shorthand name pour over will, and pour as if you're pouring a glass of water. And what it's designed to do is pour over the assets from your probate estate into your trust estate if they were left out of your trust, whether intentionally or inadvertently.
Is there a mistake that you have seen financial advisors make when they're doing planning for their clients or trying to do estate planning for their clients?
Depending on the financial advisor and what they're trying to do, sometimes they're very conversant in estate planning, and it's been my experience that I will only work with financial planners that have quite a bit of experience and training in the area and that come highly recommended to me from other people. Because if you have somebody who's just trying to push financial products because of what they can get out of it, whether it be commissions and things like that, and they really aren't conversant with the estate planning consequences of what they're advising, that can be problematic. So it's good to work with estate planning professionals that are able to dovetail their financial product, with the estate planning that's been done so that assets can be included in the estate planning, whether it be during lifetime or at death as a result of a beneficiary designation.
Is there anything else you'd like to add to the conversation?
No, I think it's incumbent on all of us to be educated as far as our own planning is concerned, and especially in days like these where it seems like you can't turn on the television without feeling nervous about everything, whether it be finances or politics, whatever it is. Things are just, there's a lot of upheaval. And so this is a good time to make sure that your estate plan doesn't create that kind of upheaval in your own family, just kind of as a mirror of what's going on in society. So I think it would be incumbent on all of us to make sure that we have those things in order, working with a qualified financial advisor, working with a qualified estate planning attorney to make sure that both your finances and your planning are in order.
Okay. Well, thank you very much for your time today, George. We appreciate it. And if you'd like to sit down for an appointment with George or get a review done of your current trust or your current will, please give us our office a phone call at 951-244-6702, and we can schedule an appointment for you to sit down with him and have things reviewed or set up. Our main goal here at the Dwayne Johnson Group and Bridger Financial Services is to make sure our clients know that they can make it to and through retirement and spend with confidence during those years. We want to make sure that they have financial security in any economy. So thank you for listening to the Retirement DNA podcast today. If you have any questions or would like to sit down with us for an initial consultation to see if you're on track to meet your secure retirement, please give us a phone call at 951-244-6702. Again, that's 951-244-6702. If you like what we've talked about today, please subscribe to our bi-weekly podcast. Please tell your friends and family if you think they'd benefit from hearing this information as well. You can also check us out at the DwayneJohnsonGroup.com and BridgerFinancialServices.com. Thank you and have a great day.
Investment advisory services offered through Bridger Financial Services, LLC, a registered investment advisor in the state of California. Insurance products and services are offered through Dwayne Johnson Group, LLC, affiliated company. Investing involves risk, including the potential loss of principal. Any references to protection, safety, or lifetime income generally refer to fixed insurance products, never securities or investments. Insurance guarantees are backed by the financial strength and claims paying abilities of the issuing carrier. This podcast is intended for informational purposes only. It is not intended to be used as the sole basis for financial decisions, nor should it be construed as advice designed to meet the particular needs of an individual situation. Dwayne Johnson Group, LLC is not permitted to offer, and no statement made during the show shall constitute tax or legal advice. Our firm is not affiliated with or endorsed by the U.S. government or any governmental agency. The information and opinions contained herein provided by third parties have been obtained from sources believed to be reliable, but accuracy and completeness cannot be guaranteed by Dwayne Johnson Group, LLC.